I'd like to start by thanking you very much indeed for giving me this chance to talk to you. I've never talked to a group of distinguished judges in my life before, but here it's about 3 Japanese judges many years ago, and even in terms of numbers, you defeat them. So thank you very much indeed for this opportunity, and to Frank for inviting me, and John for organising it. I'll try and keep it quite very, very broad brush. But obviously, if we want to go in detail down 1 or 2 things, then we can. So in the first session, what I want to do is to fill in the context of the argument in The Origins of English Individualism, and then to deal briefly with the first chapter, which is on some aspects of ownership between 1300 and 1450, that you read. All my work is really about 2 big questions. What is our basic nature as human beings? For instance, is the love of liberty intrinsic to us or something created by culture? I pursue this as an anthropologist and as a historian. And obviously, one way to look at this is to see what is the shape of the transition to our modern world. Is our modern world normal, abnormal, and where did it come from? And a lot of my work, particularly in this book, is resolving around 2 very different models. The one that Frank drew your attention to, which I was brought up learning at university, at Oxford, reading history and so on, which is basically very similar to a Marxist model. There was a world which all societies lived in, agrarian, peasant, feudal, embedded, using Macfarlane's phrase, A. Then there was a great transition, often thought to be between about the 16th and 17th century, a watershed. This is the view of Marx, Weber, and others to a large extent. And then you get the growth of an entirely different world, our world, contractual, private property, and all those sorts of things. This is the revolution, 17th, 16th, 17th century revolution, from A to B. Now that's what I always believed. But my book is about how I came to unbelieve it, and to think much more in terms of a metaphor which is used by E.P. Thompson and others, of a great arch of history. But there's no point at which you could say a bridge is broken. Starting, say, at 1000 AD to 2000 is one continuous sweep. There are moments of importance, like the ones Frank mentioned, but there's no great moment when it all changes. Now, this endeavour to try and understand this problem is obviously very complex. And just to give you an idea of the window which you look through as part of a general corpus of work, you've read 3 chapters of The Origins of English Individualism, hopefully, or you have them. They are 1/4 of the book, The Origins of English Individualism, which is 1/4 of a set of 4 books trying to understand this problem. The one after that is The Culture of Capitalism, written 10 years later. Then recently I've written 2 more called The Riddle of the Modern World, The Making of the Modern World, which finally solves the problems I set out in Individualism some 25 years later, how this happened. I leave it open at the end of this, but finally I sorted it out in my mind what happened and how it happened. And that's only in the last book, The Making of the Modern World, which is by Macfarlane, a Japanese philosopher, Tucson. Now that whole corpus, in turn, is only 1/4 of the 16 books I've published, which cover different aspects, not just this kind of political philosophy and legal side, but the cultural side, witchcraft, marriage, love, demography, all sorts of things. So there are another 12 books. And that whole corpus of books is only a part of the work that my wife Sarah and I do, because it's based on a huge amount of set of databases of very, very detailed work on particular sets of data, historical, anthropological. That has actually absorbed as much time as the writing, probably more, because one of the problems hitherto has been that a lot of speculation has been based on secondary sources or just dabbling around in the data. And I think it was this encounter with specific factual data from legal records or from community studies which has helped me reshape my work. The heart of what is in this book is mainly focused, as you know, on property, and the quintessence of it, if you like, can be represented as follows. In a simple diagram, the normal picture of how pre-industrial, pre-modern property systems work envisage a set of resources in which a number of individuals have rights, usually in peasant societies, a family group. So the unit of production, the family, is the same as the unit of consumption, and you have Marx's famous sack of potatoes, each separate and each owning property. The essence of modernity in this sense is that you have resources, and you have people who have relations with each other in those resources. And so you have a separation of the unit of production and consumption. And that is the great revolutionary change. I had always believed, as I said, that you'd had the great change from the first to the second, as was conventionally thought in the 16th, 17th century. What I think, there were one or two things that shook my belief in this. The first was going back to the original record. Those of you who are interested, my wife Sarah and I did a reconstruction of all the records of one English village right across this watershed from 1375 to 1854. This is the only time in history this has ever been done, to go back to all the equity court records, the ecclesiastical court records, the memorial records, the common law records, all the field records, the testaments, wills, and everything. And the whole lot are indexed and transcribed. Thousands of pages of English historical records. It was a dream that F.W. Maitland had in relation to the memorial courts, but we've done it to all the courts. There are land maps from the 16th century, so you can trace each land holding and transfer of all the properties for 500 years. You can work out all the family relations and so on. It's all available on the World Wide Web on my website, right on the front page. So if you want to see the evolving nature of English legal system and so on, this is a resource. And it was working on that that began, I suppose, without really thinking about it, to undermine what I had understood, because when I came to think about it and write about it, I discovered there was no moment at which there was a great transition. That the records before the Reformation were the same as the records more or less with a slight weakening of the influence of the church courts. After the Reformation, the records of the 14th century were in no sense really different from those of the 17th century. Secondly, I think what shook my belief was that the experience of actually living in a peasant community in the Himalayas. I went as an anthropologist and worked for 15 months there. And when I came back and then really looked at the English past, I saw how very different it was. Many of the speculations on English medieval peasants and so on were made by people who never lived in such societies, often from Eastern Europe, Kosminski, Vinogradov, Tito, Boston and others. And they projected back their vague memories of what early Russia or peasant work was like, but they never actually lived in these sorts of places. And when I came back, I found it was very different. Thirdly, I rediscovered the work of earlier legal historians. What had happened, as often happens in history, is that the great works of the late 19th century legal historians, like particularly F.W. Maitland, had been not shown to be wrong, but just ignored, so that when I went through 6 years of history at Oxford without ever hearing the word Maitland, but in fact almost everything I have to say was anticipated by Maitland. So I came to write this book. At the beginning, as I explained, I expected to find something entirely different. But the bits that you haven't read, which I'll summarise very briefly, quickly, is follows. In the first chapter, The Nature of a Peasant Society, I set up an ideal type model against which I would measure English society. I look particularly at East European peasantries and also peasantries all around the world. And I define the quintessence of peasantry as this merging of the social and the economic and the absence of private individual property. That is the quintessence of peasantry, and it's uniform through very many peasantries around the world. So having got a model against which, or benchmark against which to set the data, I set out in the second chapter the received wisdom as to when England stopped being like that. All my teachers, Christopher Hill, Eric Hobsbawm, famous Marxist historians and others, had all, R.H. Tawney in particular, had accepted this great watershed theory, the transition theory. So I set them all up and described what I had been taught basically, what was the current paradigm. Then in the third chapter, I started going backwards in time. I looked at the English economy and society in the 16th and 17th centuries, and I looked particularly at the diary of the 17th century clergyman, which is all on this. It's the best village diary of the 17th century, Ralph Justin, it's all on the website. And he didn't act at all like a peasant. There were no hints of peasantry in the 16th and 17th centuries, as far as I could see in the records. He was commercialised, contractual, individualistic. There was no question that the family owned any property. So this began to surprise me, because already there should have been still quite a lot left in the 16th and 17th century in terms of peasant morality and mentality and land culture. But it was clear that by the 16th and 17th century, children could own property, they could be disinherited, the individual and the farm were not blended, land was a marketable commodity, and so on. So it was quite clear that there was no peasantry then. So I went back, I thought, well, when did they come? They must have come just before this. So the next chapter, ownership in England from 1350 to 1750, I examined property law for that period. Again, much to my surprise, in that 400 years after the Black Death, there was no evidence of communal peasant property, of a family owning as a family. Women, for instance, could hold individual property, free alienation without the heir's consent, as Maitland pointed out, was accepted by 1300. There's extensive documentation of the fact that individual private property was present. There was no watershed discernible in the legal records or court cases. So when you looked at the common law or to the church law, it's the same thing. Land is treated as a marketable commodity. There's no family claim on land. So it's pretty clear that this was a non-peasant world. Now that's getting quite late, quite early. That's back to the Black Death around that period. But I still thought I would find something. It was like a detective story. The rainbow kept moving away, and I thought, well, just beyond there, it must have been the watershed of the Black Death, extinguished the peasants, the villains went to the 14th century or something. So the next, am I talking too long? All right. Okay? I just won't be going on much more, then I'll have a chance to comment. The next one is really the key chapter, the most difficult chapter, the one before the one that you read. It's called Ownership in England from 1200 to 1350. This is the most technical because the evidence is very sketchy, slender, and you have to infer from things. And so it's one that was the most difficult to write. Because in a way it's rather like science as well, defined by modern philosophers of science. I couldn't prove that there were no peasants. You can't prove a negative. All I could prove was that there was no evidence, as far as I can see, for peasants and this kind of embedded world. So what I did was to look at the classic works of medieval historians, particularly G.C. Homans in his English literature in the 13th century. And I looked at the contemporary legal tracts like Brandon's Laws of England, But if you looked at freehold property, there was no doubt that freehold property was held individually, not by any family group. So the large part of England that was held by freehold tenants was clearly not peasant property. Then,
can you tell me again what peasant property means legally?
Well, it means that the father in the family holds the land in trust. He has no right to dispose of it. There's what French call restraint, a restraint of the line, so that when a person is born into that unit.
Wouldn't feet-tail be like that? Are you describing feet-tail?
No. Well, to give you an example, where we work in the Himalayas, all the sons automatically have complete rights in land. Their parents can't sell the land without their agreement, and they, by birth, inherit 1/3 or 1/5. Now, in the 12th, 13th century, the thing is really summarised in one small Latin phrase by Bracton. Nemo est heredis viventis. No man is the heir of a living man. In other words, as long as the father is alive, or the mother is alive, they have complete and freedom to dispose of property. So, obviously, you can leave property to your children. Obviously, if there is no device used to leave it away from your children, if you haven't sold it during your lifetime and you don't leave a will leaving it to someone else, then it will automatically by English court leave it to your heirs. But if you make a will, you can break that, you can will it away from your children. And if you have received property from your father or bought it during your lifetime, you can just sell it. If your son says, I'm 16, soon I would inherit this property, don't sell it. He can't do anything about it.
My impression is it was specifically the aristocracy that was barred from selling off the land in that way. There was that, and there were heirlooms, for example.
No, well, it's a long and complicated story, because what happened was entailing property. There was this constant battle, as some of you know, with medieval law, whereby one set of lawyers were trying to set up entails and make sure that the property remained within, and another bunch were dedicated to devising ways of breaking entails. And so at some periods and in some cases you could force the land to follow a property line. Other times there were people who could easily get around this. But it's certainly true that the one group that is closest, in a sense, are the higher aristocracy. But
in terms of the lower downs, just so I understand it, there was no class of people, whatever you call them, tied to the land as serfs. Is that right?
Well, the position of serfs is very difficult for people to understand. Serfdom is a property relation. That's to say, a serf has a particular relationship to the lord of the manor, which is a property relationship, but it's very different in every respect, obviously, from slavery. The serf is unfree in terms of giving his labour and perhaps mobility, but the lord cannot treat him as a chattel good. He can't sell him off, he can't kill him, he can't maim him or destroy him. And in relation to other people who are not the lord, the serf has equal rights to every other individual. In other words, it's very like, I was thinking of this the other day, nowadays, there is a contractual relationship or maybe a long-term relationship with a particular person, but it's not a status which affects your relations with other people. So I might be your serf, but if a gentleman here attacks me because he says, oh, you're just a serf, then I can take my case to the courts for damages.
You can't move.
Sorry? You
can't move to London.
Well, again, de facto and de jure, there's a huge difference. In principle, you shouldn't do de jure. In de facto, there was a huge amount of migration and movement, and it really wasn't worth pursuing these people. This whole sort of muddled situation explains one of the great mysteries of history. No one understood how villains disappeared in the 15th century. There was no emancipation legislation brought in or anything. There were quite a lot of these people before the Black Death. Then after the Black Death, as the demography changes, they just vanish, which is because really it was a labour relationship which worked in a particular demography, and after that it didn't. And in the 16th century there were more villains, but nothing's happened. They've never been freed or emancipated.
What you're saying is that it was a voluntary relationship.
I think voluntary is a bit strong, probably. I don't suppose that all villains really wanted to be villains, but it was a contractual relationship in the sense that there were specific rights and duties on each side. In other words, it wasn't a status. You weren't born and necessarily always going to be in this position. There were ways of getting out of it.
If the serf took off someplace in England, went to London, what was the recourse of the lord of the manor, if any?
Well, I think he could try and repossess his serf, and it's not something I'm a specialist on, but we're always told in legal histories and so on that that's the case. He could bring a case and try and apprehend the person and bring them back. But the difficulties of doing so would have been immense. I mean, there's no police force except of local constables and so on. I mean, how do you keep an unwilling serf on your estate if he keeps running off? There are very few punishments, and it just wouldn't have been worth the bother if the person was really determined to go. I'll just finish here, and then I'll come back to. Sorry.
I'm sorry. Just one quick question.
Yeah.
Magna Carta. How does that affect England as far as property rights and what you're talking about?
Well, it again re-emphasizes the property rights of individuals, particularly in one relationship, and this is obviously in relationship to the king, because the one weakness in this whole system had always been that as the royal power grew, and this is what it's all about, the claims and force of the royal power to take property from major landholders, freeholders, was always in threat. In the continent, which I'll come to later, you got this development of a system whereby the royal power grew to such an extent that all lower individuals were subject to arbitrary seizure of their property. And a lot of Magna Carta is concerned with saying that you can't have your property seized during your lifetime by the king without due cause or warrant. So
it wasn't like our Bill of Rights in the sense that we didn't give any individual rights to uphold, we're calling the serfs and peasants, whatever. It was just a relationship between the large property owners and, say, the king.
Yes, that's right. It's very different. Yeah. Okay, I'm nearly finished actually this particular bit, and then we can proceed further. Basically, the freehold lands were, you could entail them, but they were held by an individual and then entailed down a line, or you could sell them, if you were a smaller freeholder, you could sell them, buy them, and so on. The copyhold lands held of the manor courts by copy of court roll, it's quite clear that if you look at the actual transfers, and this is quite technical in the book, because Homans and others thought that they had discovered that in the wording that there was some restraint so that the family held the land. But I went through the documents one by one, each case that had been put forward by medievalists, and I found that as far as I could see, by using false analogies, putting the wrong stress on certain Latin words, Homans managed to concoct a picture which bore little relationship to reality. This is a rather rash thing of mine for me to do, because I'm not a medievalist, and I took on most of the medievalists, Raptis, Homans, Titov, and others. But no one in the replies, and there was an equal length of the reviews of this book were longer than the book itself. In I went through all those again. None of them, as far as I was concerned, no one was prejudiced, of course, seemed to get round what I was saying. They just reasserted what they said before without any evidence that really there was a blood right. So basically land sales went on, and we'll come to this. The actual technical legal position in relation to property, which this chapter was about, seemed to suggest that this was a world where each individual, you could say, I mean, the essence of it is, here you and I can say, this is mine. I can do what I like with it, I can sell it, I can dispose of it, I can destroy it. I have a bundle of rights, which is property, all those rights in here in this, and they are according to my will. And if I want to get rid of it during my lifetime or leave it to someone, I can do that. That is the essence of modern privatized property. If I was in the Himalayas in Nepal, if there was a book on the shelf in the house I live in there, or there was an ox, or an animal, or a field, I couldn't, as the head of the household, just say, we're getting rid of that ox, or I'm going to sell that field, because it doesn't belong to me. The rights, the bundle of rights is, every person by birth has rights in that property. So you are a lump. A property only uses 4 or 5 people. In simpler societies, it's often much wider, a whole lineage of people, but by the time you get to peasantries, you've got a small group of people, 4 or 5 people, or all the children, all the brothers, and no single individual owns it. You can't say, this is mine. And this causes both difficulties and great advantages. It also explains the development in that period of a very extensive land market. One of the problems medievals had was that if property is peasant property, what you find in peasant societies is characteristic, and you don't buy and sell land, because land is a family. You might sell little peripheral bits, but on the whole you don't sell family land, you hold on to it for dear life. But most medievalists had admitted and found that there was a huge property market, people buying and selling land all the time in the 13th and 14th centuries. This might have given them some realization that they were dealing with something odd, but they managed to somehow fit in these exceptions or just a short period or something like this. So basically there was a true land market and true individualistic property. That was where I got to at the point at which you started reading.
You might distinguish between freehold and copyhold.
Yes.
There's that leverage.
Yes, freehold, it's putting it very simply, one oddness which distinguishes England from all other parts of Europe is that you have the king who, in England, the king owns every piece of land. There are no allods, as they're called, A-L-L-O-D-S in England. There's no allodial land from the 12th century in England. Not a single scrap of land in England is held by an individual at a lower level. So the king has lieutenants-in-chief, which might be the Earl of Warwick, or it might be me, Alfred. And I hold it freely of the king, that's a freehold. Then you have this other sort of institution, which the king has a sort of clump of rights, which is often called a manor, which is not just land, but a little set of other perquisites rights, like rights to hold a court baron, and so on and so on. This manor is held by person A, of the king. Then this person has a manor and a manorial jurisdiction. And in Earl's Code there's a map which shows the proportions something like 2/3 of Earl's Coombe is held in two manors, Macfarlane and Earl's Coombe. And these people here hold of the manor by copy of court roll. The legal entitlement, you can read it. They make the court transfer it, and then they make a little copy on a manuscript to give it to the person. So this is known as copyhold. There's also leasehold, which is different. But much of England is held by copyhold. And the conventional wisdom was that this land was peasant land. And the essence of what we were showing was that when a person had a copy of court roll, it said, I give to so-and-so the right to hold this field or these fields in return for certain rents, payments and services and so on. And the person who had this, John Cook or someone, he held it himself. It might be a woman, might be a man, might be for a term of years or whatever. No one else was involved. Now, one of the reasons that the medievalists got a bit confused was that quite often you do find in the court rolls that several people come in. So you get a man coming in with his son to take over this piece of land. Well, that is a joint tenure, so that when it goes on, it passes on. So they're holding it jointly. But this is it's not a peasant family, it's just that two people have decided to join up, so to speak, and to take a piece of land, and when one of them dies, it will go on. But even then, there is a moment when it has to revert to the court and be transferred back down, so it's not a true peasant situation. The coexist over long periods of history, and there's a tension between them. Our family system, that is modern nuclear individualistic family system in which we live, emerged out of a lineage, family, corporate, peasant kind of world. That is true in many societies, but it's not true in the English case. It goes back centuries and centuries, as far back as we can go. And it makes all things have a much longer period, even industrialization. The Industrial Revolution of the 18th century is not something that happened in the 18th century. It was already starting in the 12th, 13th century, the replacement of human labor by machines. At that time, water power was much older. And at the heart of it is property. Secure private individual property is safeguarded. The Lockean view that this is the bedrock of a stable and prosperous society, and so on and so on. And I was accused by many of my, not just Marxists, but my socialists and other friends of rewriting English history to justify free market economics, libertarian views, liberty, individualism, all these sorts of things towards that end, rather than towards the idea that we have much of wealth should be communalized and so on and so on. That's really what I meant. I don't want to continue. It was emphasizing that